Good morning, everyone. Thank you very much for joining us this morning for today's Program on Extremism event, Hitting the Terrorist Wallet, Understanding the Growing Use of U.S. Civil Courts Against Hamas and Other Terrorist Organizations. My name is Rosa Cabuz, and I'm a research fellow at the Program on Extremism. And I'm pleased to introduce Jeff Brehol, who will be the one moderating today's event. Jeff recently retired from a long and distinguished career at DOJ, where he was a key player in the government's response to 9/11. And today he's a senior fellow here at the Program on Extremism. Jeff, the floor is yours whenever you want.
Okay, thank you, Rosa, and good morning and welcome to everybody we have on this broadcast. This is a timely event that is being hosted by George Washington University's Program on Extremism, entitled Hitting Their Wallets, the Growing Use of Civil Courts Against Hamas and Other Terrorist Organizations. My name is Jeff Breinholt. I'm a senior research fellow here at the Project on Extremism. And what we're going to talk about today is the Anti-Terrorism Act, which is codified at Title 18 U.S.C. Section 2333. And which is known as the Anti-Terrorism Act, or the HEA, is, along with the Foreign Sovereign Immunities Act, a remedy for lawyers who represent victims of terrorism. And they're different statutes, and today we're primarily going to be talking about the HEA. We have a distinguished panel of industry leaders here, all of whom have worked on the plaintiff's side. And I must say, this is a personal note, I come at this issue from a very particular perspective, in that I was always on the criminal side. I was working terrorist financing after 9/11, and I was always on the criminal side. And I can tell you that when I stumbled on these cases that some of these panelists have handled, I got really excited, because there's a phenomenon that even if the defendant in an HEA or an FSIA case is not present, the court still has to find the requisite elements in the case. And so basically what happens there is the plaintiff's counsel or victim's counsel puts on their case, and the judge decides it in a default. But the result is there's probably over 100 very well-reasoned opinions, mostly arising out of the DC District Court here in Washington. And I think it's a pretty exciting thing. It gives free intelligence to people like me who are on the criminal side. And so I got myself wrapped up around a lot of these civil cases, and I got to know the practitioners. And ultimately, I ended up working for Ken Feinberg, who was appointed by the Attorney General as a special master for the Foreign Sovereign Immunities Act default judgment holders. And so we've been paying them out of a fund that is consisting of bank fines that have been secured by law enforcement around the country and around the world primarily. So long way of saying that I think there's enormous amount of strategic intelligence to be had by analyzing these cases that we're going to hear about today. There's also something that you'll see when you play around with our website. We have a new report out at the Program on Extremism called the 2333 Encyclopedia. And what it is a 100-page report which lists in alphabetical order every single HEA case that has hit Westlaw since its enactment in 1992. And I count about 158 matters. Now, it's not surprising, and maybe these guys can touch on this, that a lot of people use the HEA to pursue their own vendetta. And that's true of a lot of these frivolous cases. And when that happens, they rarely find lawyers. And so the plaintiff's lawyers, these cases are pretty easy to see, because the plaintiff's lawyers are pro se. The person is representing themselves. And so I'd say about 30% of any ATA case will be those frivolous types that are dismissed fairly quickly with prejudice. The 70% of the 150 matters, and there's about 600 opinions arising out of these, but the most common defendant are banks, multinational companies, and the FTO, the Foreign Terrorist Organization themselves. And in the case of Dan Schlesinger, who we're going to hear from, U.S.-based charities have been sued as well under the ATA. The ATA, I'll just say this before I introduce our speakers. ATA in 2016 was amended by what was called the Justice Against Sponsors of Terrorism Act, JASTA, J-A-S-T-A. And that was a 2016 amendment to the ATA, which clarified once and for all Congress's intent to establish secondary or aiding and abetting liability for 2333 causes of action. Okay. And JASTA has an interesting story because President Obama only issued 12 vetoes in his 8 years as president. This JASTA was the only one that was overridden by Congress. So Congress felt very strongly about amending the ATA and adding JASTA to it. It was the only bill that was ever vetoed and overruled by Congress in Obama's tenure. And the one thing that I should point out is that it seemed to be clear at the time that the president was very mindful of the Saudi sensibilities. He was worried that the Saudis were gonna be basically bankrupted by American litigation if we let JASTA go through, and that was the basis. Maybe you can get some elaboration on that from our speaker. So with that, let me turn it over to the three speakers you're going to hear from. I'm going to give you a short bio of each of them, and you'll hear from them in the order that I'm going to introduce them. Okay. So first we have Dan Schlesinger, who is a business litigator in Chicago, and he has spent years devoting pro bono time to representing persecuted victims in asylum cases. And he is lead counsel in really the most significant domestic and early ATA case involving one of the first Americans killed intentionally in Israel, a guy by the name of David Boehm. And so we'll hear from Dan in the Boehm case, and that was sort of a hallmark case in the ATA jurisprudence. Next, we'll hear from Gary Osen, who is managing partner at Osen LLC, a great law firm that does a lot of terrorist financing, and I follow very closely. He has served as lead counsel in several major terrorist financing cases pending in federal courts, including Freeman, Averbach, and Spetner, and these are all listed in the report. He has been involved heavily. Oh, by the way, and he is also an alumnus of GW University Law School. So this is sort of old home day for you. I'm glad to have you back on campus, even if it's virtually. And last, we'll hear from John Eubanks, who is a partner at Motley Rice in Mount Pleasant, South Carolina. And he, like Gary Osen, has been involved in FSIA and ATA cases, and he's going to tell you some of his views on the statute and how it can be improved. Now, I want to pose one question before I turn it over to Dan, and that is, to the extent you think there's a greater role for the Department of Justice, terrorism prosecutorial force, and plaintiffs' counsel in victims' cases, I would like to consider that as sort of an overarching question that we have is to the extent that the DOJ can buy more into these cases, will it help you guys in your pursuit? So with that, let me turn it over to Dan.
Thanks very much, Jeff. Let me try to share my screen here. Oops. It's not right. Is that sharing?
I can see it now.
You see it? Okay.
Yeah.
So I'm going to try to go through litigation that's originated about 25 years ago, and I'm going to try to do it in 10 or 15 minutes. So I'm going to fly through it a little quickly. I hope this works, and the PowerPoint should help a little bit. So not sure. Try this again. Okay, so David Boehm, as Jeff mentioned, was murdered by Hamas terrorists in 1996, the first American killed by Hamas terrorists. Sorry about this. The lawsuit was filed in 2000 by one of my predecessors on the case, resulted in a $156 million judgment under the ATA that was entered in December 2004 in favor of the Mr. and Mrs. Boehm, David's parents, and against defendants, including the Islamic Association for Palestine and the American Muslim Society. That judgment was reversed by a panel of the Seventh Circuit on appeal, but then reinstated in an en banc hearing as to IAP and AMS, the two of the defendants. And there were several significant rulings in that opinion by Judge Posner. One was he recognized the application of the ATA to those providing material support to terrorism. That was still a somewhat controversial topic at the time. He also validated the application of the ATA to acts occurring outside the United States. Another question, the extraterritorial application of the ATA. Because David Boehm was, of course, killed by a terrorist attack in Israel. Judge Posner explained another controversial point, which was controversial with his colleagues in the Seventh Circuit. That is, whether contributing to the charitable aspects of a terrorist organization such as Hamas could still be viewed as supporting terrorism. And then finally, the last point I wanted to raise is that he pointed out that donors sometimes use intermediary charities to transfer funds, but by doing so, they do not diminish their liability. And there were some pithy quotes that I wanted to go through from Judge Posner that I think are very important. The first one, giving money to Hamas, like giving a loaded gun to a child, which is also not a violent act, is an act that's dangerous to human life. He noted that damages are a less effective remedy against terrorists and their organizations than against their financial angels, such as the charities that are funneling money to Hamas. He said, if you give money to an organization that you know to be engaged in terrorism, the fact that you earmark it for the organization's non-terrorist activities does not get you off the liability hook. In other words, giving money to a Hamas-run hospital is still support for Hamas. He noted that the reasons for that are twofold. The first is fungibility of money, and the second, that Hamas's social welfare activities reinforced its terrorist activities both directly and by providing assistance to the families of the killed, wounded, and captured Hamas fighters, making it more costly for them to defect, and indirectly by enhancing Hamas's popularity among the Palestinian population and providing funds for indoctrinating school children. He said that to require proof that the donor intended that his contribution be used for terrorism, to make a benign intent a defense would, as a practical matter, eliminate donor liability, except in cases in which the donor was foolish enough to admit his true intent. And then the last quote I want to give is that donors to terrorism should not be able to escape liability because terrorists and their supporters launder donations through a chain of intermediate organizations. Okay, so the en banc panel in 2007 sent the case or affirmed the judgment against the Boehmes. And then what happened, in favor of the Boehmes against IAP and AMS. And IAP and AMP, the AMS, that should say, of course, stopped operating. They went out of business without paying very much of the judgment, this $156 million judgment at all. In 2017, we then filed a second Boehm case. What happened was we recognized that two new charities, AMP, the American Muslims for Palestine, and AJP, the Americans for Justice in Palestine Educational Fund, were essentially acting in the same manner as their predecessors, IAP, with a lot of the same leadership, a lot of the same operation methods. And so we chose to use an alter ego theory to file against these new charities, essentially alleging that they were the same organizations. We took some jurisdictional discovery, and that eventually resulted in a dismissal of our case by the district judge. We then went back up to the Seventh Circuit and got another reversal. And this time the three-judge panel, with an opinion written by Judge Scudder here in the Seventh Circuit, reversed and reinstated our case, upholding our jurisdictional arguments and validating our alter ego theory in a nonprofit context. That was another difficult point because while alter ego theory is very well established in the business world, in the not-for-profit world, it's not that well developed a concept, and it wasn't clear that we were going to be able to pursue these new organizations using our theme. In addition, Judge Scudder, in his opinion, provided some guidance on the legal standard that should be used for applying the alter ego theory in the not-for-profit context. What he said was, the alter ego doctrine is not rigid and must account for the context in which the doctrine is being applied. Here to terrorism financing organizations. It's difficult to see how substantial similarity or lack thereof in customers, equipment, or ownership would have any meaningful bearing on the alter ego inquiry in the context of terrorism financing nonprofit organizations, which do not have customers, equipment, or owners in the traditional corporate sense. So the traditional application of alter ego in the business world, you had to look at things like overlap of customers, equipment, assets, those kinds of things. But in the not-for-profit context, particularly terrorism financiers, factors like overlap in leadership, same organizational purpose, similarity of operations, and unlawful motive or intent to escape liability would seem to take on added weight. And then specifically addressing our amended complaint, he said that it is replete with factual allegations that show, in our view, that American Muslims for Palestine is a disguised continuance of the original defendants, Islamic Association for Palestine and Holy Land Foundation. And in that way, AMP played a role in the original wrongdoing that led to the Boehm son's murder at the hands of Hamas. So Judge Scudder's opinion reinstated our case. We were remanded back to Judge Coleman, our district judge, who then transferred the case to Judge Feinerman. Judge Feinerman decided some motions to dismiss that the defendants filed before he left the bench. And in his opinion, he said some things that are very helpful to our case now, including that specifically the Boehm's alleged facts supporting each factor the Seventh Circuit identified as relevant to a determination of alter ego liability in the context of this particular case. Things like overlap in leadership, same organizational purpose, similarity of operations, and unlawful motive or intent to escape liability, all points that we had alleged in our amended complaint. So Judge Feinerman went on to say Thus, although they do not completely overlap, the respective leaderships of AMS-IAP and entity defendants are substantially similar. The entity defendants being AMP and AJP are defendants in the current case. In particular, going through some of these points, Judge Feinerman said, the complaint alleges that the entity defendants used Holy Land's and AMS-IAP's intangible assets, again, staying away from the tangible assets that would be the focus in a business case. In the not-for-profit case, used intangible assets to raise money, spread the message, advance the pro-Hamas objectives, provide a fundraising platform for Hamas funding, and provide indirect support for Hamas itself, just as the defendants in the initial point case had. The third point, third factor, the complaint alleges that the entity defendants' operations are substantially similar to those of the original defendants, Holy Land and AMS-IAP. And then finally, the complaint alleges that the entity defendants were formed with an unlawful motive to escape the liability that was imposed in the first Boehm case. And summing up, Judge Feinerman said, the pertinent factors identified by the Seventh Circuit and discussed by the parties support the Boehm's claim that the entity defendants are liable for the first Boehm judgment as alter egos. So establishing exactly the theory that we wanted to pursue in the current Boehm case. So after Judge Feinerman left the bench, the case was reassigned to Judge Wood, where it remains today. A lot of additional discovery has been taken. Fact discovery is still going on. Depositions are being taken of some of the AMP leadership. We're taking third-party depositions, and the case continues. And that is the current status. Sorry to go through that kind of quickly, but did want to stick to my time limits here. Thanks
okay. All right. Thank you, Dan Schlesinger. Next, we're going to hear from Gary Osen. Gary, go take it away.
Okay, I am not going to depend on myself for the PowerPoint presentation this morning, so hopefully we get started. I'm going to sort of lay this out in sort of three different ways. One is giving you a sense of what an actual civil terrorism trial looks like and what it yields in terms of the evidence. Then talk about the challenges in putting together an ATA case in terms of the kinds of evidence that are gathered before filing and independent of discovery during the cases, and then talk a little bit about the law, how it's evolved over the years, and the challenges that we face in the current climate based on legal rulings since JASTA was enacted, as Jeff alluded to, in 2016. So I'll start with Lindy versus Arab Bank, which remains to this day the first and only trial against a financial institution under the ATA. So if we could turn to slide 2, please. So here you have just one slide or cross-section of some of the account holders Arab Bank held, and this was all developed during discovery in the case. Some of you will recognize on the far left of the screen Sheikh Ahmed Yassin, who was the founder and spiritual leader of Hamas before he was assassinated by Israel in 2004. The current leader of Hamas, Ismail Haniyeh, as you see there, was also an account holder and recipient of fairly large sums of money that we could trace from Hamas in Lebanon and Syria to the Gaza Strip. Mr. Haniyeh is more popularly known today for his appearances in Qatar, where he lives in safety under the protection of the Qatari regime, and is obviously one of the primary spokesmen for Hamas since October 7th. Lastly, just on this slide, you'll see in the middle Ghazi Hamad, who is also a very prominent Hamas leader, also now living primarily in Qatar, but at the time of the case, which was 2000 to 2004, Mr. Hamad was in the Gaza Strip. Again, today he's best known for his appearances on the BBC and other outlets, promising that Hamas will perpetrate additional October 7th-like attacks. So this gives you a sense of how much of the Hamas leadership actually was not only banking with Arab Bank, but also using the bank as a means to facilitate transfers from abroad to facilitate and fund the operations of Hamas, both in the Gaza Strip. This happens to be a slide from the Gaza Strip, but also for the leadership of Hamas in the West Bank. Now, Lindy was a case brought, again, just to step back for a moment, it was brought in 2004 on behalf of American citizens who were killed or injured, primarily in suicide bombing attacks during the Second Intifada, and was followed up with additional cases by other firms and ultimately by a very large case that went under different names, but ultimately was referred to as the Jesner case against Arab Bank, brought under the Alien Tort Statute. And the theory of the case was that Arab Bank was a central conduit for funding of Hamas during the Second Intifada period. We won't get into all the details, but one of the key allegations proven at trial was that the Saudi committee, a so-called Saudi charity, was transferring tens of millions of dollars into the Palestinian territories and directing that the funds be collectible at local branches of Arab Bank. So if you were the family member, close family member of a suicide bomber, for example, you could go to your local branch of Arab Bank and collect the dollar equivalent of 20,000 Saudi riyal, which was $5,316.16 at the time, and show your photo ID and collect that money from the bank. So this was very much a retail operation undertaken at that level, at the branch level, with the bank assisting in the processing of what amounted, we contended, was an insurance policy or an insurance plan for people killed or injured or arrested as a result of violent terrorist activities during the Second Intifada. We can turn to the next slide. So here is again Sheikh Ahmed Yassin, notable for the fact that he was designated by the United States as a specially designated terrorist, a designation that's old, it doesn't even exist anymore. But that was in 1995 under President Clinton executive order. And of course, the key point for us is that Yassin was designated in 1995, but the account and the transactions you saw on the prior slide were from 2001. So 6 years after his designation, the bank was actively processing funds transfers for him. We can turn to the next one. And again, here you can actually see this is a product of discovery, and this was an exhibit used at trial. This is a transfer that was made by a Hamas financier or financial conduit in Lebanon. That's the branch reference there, and the transfer is made to Ahmad Ismail Yassin at his bank account 36444 in the Gaza Strip. And keep in mind, just for context, that Ahmed Yassin was almost a quadriplegic. He had some use of his arms, but was basically immobile. And at the point where he's receiving these funds. So this is a transfer of $60,000 to an individual who, if he were just a normal customer, that would be approximately the equivalent of 10 to 12 years of average salary for a family in Gaza at the time. So again, if you were just looking at this from a normal AML compliance standpoint, you have a person who cannot work, who is receiving essentially 12 times an annual salary in one transaction. So again, it's kind of besides the point because Ahmed Yassin was probably the most recognizable face in the Middle East until Osama bin Laden masterminded the 9/11 attacks. But if you pretended that he was not known otherwise, even on its own terms, the transfer in question would have been highly questionable. We can turn to the next slide if we can. So here is Osama Hamdan, who used to be the Hamas spokesperson in Lebanon. He moved on to a new posting since then in Tehran, but he held an account at Arab Bank in Beirut. That account was advertised on Hamas's website, showing the importance of open source material, because Hamas actually on their website used to solicit contributions to an account. It didn't name who it belonged to, but it indicated that you could send money to that account. When we eventually were able to extract the account information from the bank, we saw that it belonged to Osama Hamdan, who himself is a specially designated global terrorist. And of course, of some note is the fact that some of the donors, in this case, who sent money to this account, wanted to make sure that it was clear who the funds were intended for. And so they actually wrote out both in phonetically from Arabic and as you see below it, to indicate that the funds should go to Hamas. And that's the kind of evidence that you don't see every day. Obviously, there are not that many terrorists or terrorist supporters are dumb enough to write the name of the terrorist organization on the memo line. But this is one of those fortunate, happy examples where it happened. I'd like to skip, if I can, one slide over to slide 7, if that's okay. Thank you. So what you saw up until now was the result of 10 years of discovery disputes and Rule 26 discovery in a case that's active. But even before you get to file your case, there has to be a pre-filing investigation. And there are just challenges both when you file or before you file and then afterwards. So the pre-filing investigation, we often rely upon open source materials, materials provided by whistleblowers, documents that have been leaked from various sources, and court files and government records that are sometimes utilized and can be mined for significant data. So if we can, I'd like to set up the next slide or the video that goes with it by giving a little context for it. Because one of the issues that comes up in some of our cases is the clandestine role of terrorist organizations behind the scenes. And the clip I'm about to play, hopefully, is of Abu Mahdi al-Muhandis, a infamous terrorist connected with Iran, who met his timely demise with Qasem Soleimani in January of 2020. Muhandis had been a longtime operative on behalf of Iran, coordinating with Hezbollah and other terrorist groups. And here he gave an interview many years later after the U.S. and coalition forces left Iraq, in which he was explaining the role of the resistance in the earlier period, giving sort of a historical background and context to what we call the war in Iraq. And let me see if we can get it to play.
بالقرن الماضي وإلى تمتينة وعملياتية وأول من درب
Hopefully you
أول
can see the video because it has the actual
الثمانينات من القرن الماضي كان
subtitles.
ومصطفى، وكما كان لهم دور أساسي في تنظيم خلايا المقاومة ضد الأمريكان في العراق والعراقيين هنا.
We can't see the video yet.
العراقيين والخلايا الأولى للعراقيين، وأنا واحد منهم بعد 2003. بعد 2003 كان لهم دور أساسي ولا زالوا.
Okay. Maybe we could cut it since we can't see the video. Let's oh, here we go.
ولهم دور مهم جدا.
Should we just jump to the next slide? If we could go to slide 8. Okay, this is another source. Apologies for the technical problems. Here's an example of open source research. This is from the old website of Hezbollah's Islamic Resistance Support Organization. And here they're soliciting donations for the IRSO. And it's important to note, IRSO is Hezbollah's sort of charity, but directly for their terrorist activities. So like their forms give you the option of donating for a bullet, for a rocket, depends how much you want to spend, but they give you a whole sort of list of different donation options, all of which involve violence and terrorism. And as you see back in the old days, they were kind enough to post their bank account and their bank account information on the web. So that's one example, and there are others. I mentioned earlier that Hamas used to post their donation account on their website. They're more sophisticated about it today, but that's one example of where open source material works. Next, on the next slide is an example of whistleblower disclosures. This document, for example, came from a bank employee in Lebanon who disclosed a variety of information about Hezbollah front companies that were using the bank to move money. And of course, the bank's knowledge of that fact. Unfortunately, this whistleblower, I don't want to discourage future whistleblowers, but this one was murdered a couple of years ago. Turning to the next slide, this is an example of leaks or data breaches. There are a number of instances out there where different institutions have been penetrated by hackers. And one happy example of this is Hezbollah's Al-Qard al-Hassan. That is Hezbollah's own private bank. They're nominally listed as a charity, but they actually run, as you can see from the video surveillance cameras from inside the bank, they run the operation like a retail bank. And Al-Qard al-Hassan's computers were hacked, including their CCTV, and that has provided a source of enormous value and information on how Hezbollah runs its accounts, pays its employees, and so forth. We can turn to the next slide. So here we have example of government records we talked about earlier. When the United States government designates an individual, in this case, a narcotics trafficker named Ayman Juma, they have to prepare an evidentiary memorandum to support the designation. And that is one of many examples of government materials that can be used to support the evidentiary record when you're trying to either file a complaint or to provide evidence that might be potentially admissible during the course of a case. Let me jump to the next slide. So here we come to the legal challenges that are faced by practitioners in ATA cases. The first one is that although in theory, Rule 8 requires you to just make a plain statement and set forth what your claims are about, the reality is that most courts de facto apply a heightened scrutiny to ATA complaints. And that means that you have to have a lot more ammunition at the front end of your case and do a lot more pre-filing investigation than you do in almost any other field. The next challenge, of course, is that these cases tend to be defended by very large law firms that get a lot of leeway from courts and are able to push the envelope in many cases in ways that are pretty hard to believe, including sanctionable conduct. In fact, in the Lindy case that I started with, the defendant was ultimately sanctioned to the tune, I think, of more than $1 million for various discovery abuses. It's also noteworthy that quite a number of courts are hostile to the idea of secondary liability. Jeff mentioned that JASTA was enacted in part to make clear that secondary actors, that is, people other than the bombers, the terrorist organizations, etc., can be held liable for helping terrorists. But more than once, we've been asked by federal judges why we didn't sue Hezbollah or Hamas instead of the bankers or other corporate entities that assisted them. And then lastly, just a conceptual problem that we face is that, as civil litigants, we don't get the same deference that prosecutors do when it comes to describing terrorist organizations, how they work, how they move money. And so the fact that most judges don't know and have no reason to know how international terrorism works is completely understandable, but it means that for us, we have an additional burden because courts will defer to prosecutors on those kinds of details, at least at the initial stages, whereas we really have to prove time and again that we know what we're talking about in this area in order to get courts to buy in to issues. Daniel mentioned a while ago the question of charities that are involved in funding terrorism. A lot of courts don't like the idea, the concept of charitable organizations being held liable or being the source of funding for terrorism. And you have to walk them through how the terrorist organizations work, how they integrate these sort of social activities into their terror apparatus and infrastructure. So that's another challenge. We can go to the next slide. So this is just so the audience can see the actual language of JASTA, which created this sort of standalone explicit liability for those who aid and abet by knowingly providing substantial assistance to those who commit acts of international terrorism. And because time is limited, we can get into this later. I'll just go to the next slide and talk about just very briefly the Second Circuit law on this subject, which is, for many years, Boehm was the sort of gold standard of ATA case law. It was an en banc decision of the Seventh Circuit. After JASTA was passed, the courts really, for the most part, set Boehm to the side because they said that was sort of a pre-JASTA case. And the cases that followed took a very different approach to JASTA. Really, instead of seeing it as an expansion of liability, they've largely seen it as a narrowing of liability. And the case of Weiss versus National Westminster Bank, that involved transfers from many of the same entities that were involved in the Boehm case. That is, the organizations that received the money in the Palestinian territories were the same committees and social welfare organizations that belonged to Hamas. And the court found that even though the record might show that the defendant in that case knew it was providing material support to Hamas, the records did not indicate, that is, the wire transfers and the other information available to the bank did not indicate that the banks was sending funds for a terroristic purpose. And as you can see, when I referenced the Osama Hamdan account that actually had wire transfers for Hamas, that's about as good as it gets in the ATA world. I've been doing this for 20 years. I've never seen a transfer that on its face indicated it was for terrorism or for bullets. And so that standard is really impossible to meet. However, the circuit walked it back a little bit in a subsequent case called Kaplan versus Lebanese Canadian Bank, and said, no, that was very fact specific in Weiss. And in fact, what you have to show is that that the defendant was knowingly assisting an entity or person who was, quote unquote, closely intertwined with the terrorist activities of the terrorist organization. And so this is the sort of shifting landscape that we're struggling with, and we can talk about that more in the question and answer section, but let me turn it over to John.
Okay. John, see, I don't see the videos. Yeah, where we go. Okay. John, you're up next.
Okay. Let me see if I can succeed in sharing the screen. Okay. So I guess I'm coming in last here, but to show really how the community that is trying these cases is so intertwined. Dan's case, the Boehm case, I was on the front end of that case way back in 2020. I actually helped draft it, or 2000, excuse me. I helped draft the complaint, but also it was my first job out of law school, was working for the lawyers who were trying that case, and I was kind of the in-house expert on the various defendants. So, and then as Gary was talking about the Lindy case, and he gave mention of the ATS case, Jesner v. Arab Bank, I was one of the lead lawyers on Jesner, but also on some of the other American cases that were pulled together with Gary's Lindy case. So it is a community of people who are trying these types of cases. And as Gary said, it's become increasingly difficult. In light of JASTA, JASTA was supposed to make things somewhat easier, but instead it has made things slightly more difficult in terms of how we proceed in these cases and how we can succeed in these cases. But what I want to talk about today, to start out with, is kind of another area that our firm has gone into in terms of looking at what we may be able to pursue. So recently, Motley Rice has branched out into Anti-Terrorism Act litigation, dealing with violence south of the border, basically, against American citizens. Mexican cartels have become a scourge, honestly, not only by pumping fentanyl into the country and other illicit drugs, but also just through the sheer violence that is perpetrated both against Mexican nationals and also against nationals of other countries in Mexico and in the United States. In November 2019, residents of this peaceful area that you can see in the picture here were in a 3-car caravan traveling from La Mora to a place called LeBaron, which was probably about an hour and a half drive through some relatively mountainous or less than paved roads going from one place to the other. So it was on the border of the Sonora province, or Sonora and Chihuahua in Mexico. Now, these are all American citizens in these 3 cars that were going forward on this trek. Some were actually headed to the United States. Some were headed to Colonia LeBaron. As they entered onto the road, and you can see on the map here, there was a winding road going through the mountains. It was a dirt road. That dirt road had been claimed by the Juarez cartel. Juarez cartel got its start out of Ciudad Juarez in Mexico, right on the border with El Paso. And they control different areas of Mexico, but also a lot of these Mexican cartels, not only they interrelate with one another. So you have a lot of interaction. Sometimes they're fighting each other, and the next day that they're working in conjunction with one another. It's a different kind of situation than you have even in the normal terrorism context. But make no mistake, the actions that these cartels undertake are terroristic in nature. And I'll get to the definition and how they fit within that in just a moment. But the first attack here involved a mother and 4 of her kids, from a baby to age 12. Members of the cartel were on a mountainside overlooking the road. They flooded this suburban with a hail of bullets, approached, shot some more, and then, just to kind of end the situation, they doused the vehicle in some sort of accelerant, likely gasoline, and lit it on fire.
John,
At the trial we had on this matter, we had testimony from a trauma surgeon who said they were more likely than not still alive when the car was set on fire. And again, this is a mother, 4 minor children. The other 2 attacks, same situations, mother, minor children. In one situation, one of the vehicles started to be fired upon. Mother got out to show that she was not a combatant. She was not somebody from a rival cartel, but rather a mother with her child in a car seat behind her. She was shot multiple times and left in the road.
Can you advance the slides? I don't think they're not. We just see the title. If you can just like pass the slides. Does this make sense? You can scroll down.
Hold on, let me. I'm trying to. Can you see the pictures here?
No, you're still on the first slide. You can hit play slideshow and just go through the slides and get to the one that you need to speak about.
The joys of technology here. Now I'm having difficulty closing the share. Oh, there it is. Let's see if I can do this better. Is that showing the slide any better, or is this, I can, you know what, I'm going to do this without the slideshow because it's not necessary. These types of cases are always difficult, as Gary was saying. You have to bring your evidence together from the beginning. Even in this case, we sued the Juarez cartel and its armed wing called La Línea, who we knew was responsible for carrying out the attack. We weren't sure if they would show up in court. Case was filed in federal court in North Dakota. They did not show up. Nonetheless, we had the opportunity to put on a trial related to damages in this case. And as part of the damages trial, we wanted to put forward what actually happened, how they were responsible. And Gary was talking about some of the information that you're able to obtain. What we were able to obtain in this case was a level of cooperation from a foreign government that I've never seen. One of the people who was able to testify in this trial on damages in a federal court was a prosecutor in an ongoing case in Mexico, investigating the actual attack we were trying damages on. And he provided the factual findings of the prosecutor's office as to who was responsible, who had been arrested, who was still at large, how many bullets were used in each one of the incidents, and how they came to be on this road. There was a meeting days before at a ranch not too far away where members of multiple cartels met and concocted this scheme to carry out this type of an attack. So I know a lot of people might ask, well, cartel is not a designated terrorist entity. The Anti-Terrorism Act doesn't require that you're suing a designated terrorist entity or somebody who provided money to a designated terrorist entity. It provides that an act of international terrorism was carried out against a U.S. citizen. And an act of international terrorism, as it's defined in the statute, is an act that is dangerous to human life or a violation of the criminal laws of the United States or of any state, or would be a criminal violation if committed within the jurisdiction of the United States, that appears to be intended to A, intimidate or coerce the civilian population, B, influence the policy of a government by intimidation or coercion, or C, affects the conduct of government by mass destruction, assassination, or kidnapping. And then C, occurs primarily outside the territorial jurisdiction of the United States or transcends national borders. This case, we felt, fit every one of those categories. It was absolutely a violent act, dangerous to human life. It was appeared to intimidate not only the civilian population, but also to influence policies of the Mexican government in terms of cracking down on the cartels. The policy that had been adopted on this road was, if anybody tries to travel on this road that we have now claimed, we're going to shoot them. We don't care who they are. Women, children, military, police, they didn't care. They were going to shoot whoever came down that road. It just happened that they were American citizens, women and children who they killed. 3 women, 6 children, and multiple wounded children in the process. And this occurred primarily outside the territorial jurisdiction of the United States. I've dealt with terrorist organizations and terrorist issues for probably the past almost 25 years. And I can say the activities of the cartels and the way that they keep everyone around them in terror might actually surpass the level of danger that is inflicted or violent acts that are inflicted by actual terrorist organizations. Kind of switching gears, because that's a new horizon on these types of litigation. But and I know that I'm running short on time, Jeff, so I'll try and go through this relatively quickly. Motley Rice has also been at the head of litigation relating to the 9/11 attacks. And we've talked a lot about JASTA today. Gary was saying how JASTA has been interpreted to narrow the field of the types of cases that can be brought under the ATA. Now, when JASTA was passed in 2016, part of it was to allow, if there was a terrorist attack within the United States, and there was a state sponsor of that terrorist attack, it didn't matter whether they were designated as a state sponsor or not. They could be sued in the United States courts, and they could have their sovereign immunity lifted. And it also said that if their sovereign immunity was lifted, then a case could be brought against that foreign sovereign under the ATA. Same law creates the ATA liability for aiding and abetting liability. The judge in our multi-district litigation in New York, in the 9/11 litigation, so we have cases against Saudi Arabia, Sudan, and Iran as foreign sovereigns who are liable under JASTA. In a decision regarding a motion to dismiss by Sudan, Judge Daniels in the case held that the operative text of JASTA does not subject foreign sovereigns to secondary liability under the ATA because Congress restricted liability to any person as defined in the Dictionary Act rather than the broader definition of person in the ATA's definition section. And he basically determined that a foreign sovereign can't be found liable for aiding and abetting under the Anti-Terrorism Act, even though you can bring an Anti-Terrorism Act against that foreign sovereign. So that has resulted in legislative action trying to fix some certain things about JASTA. One of which is to incorporate foreign sovereigns into the definitions to allow them to be subject to aiding and abetting liability. Also to make clear who is a national of the United States. But this legislation that would be a fix to legislation that was passed in 2016 has been sitting since June 21st when it was first introduced. It seemed to be a relatively innocuous fix to prior legislation, but it's been bogged down because Saudi Arabia is potentially a defendant that could be on the hook for additional liability if this passes. And Jeff, you asked before any of us began to speak whether there would be any additional help, whether it would be helpful for us as practitioners in this field if there were more interaction with criminal prosecutors on terrorism prosecutions. Yes, that would be helpful. Unfortunately, what I've found, I think Gary has probably found the same thing, is that federal prosecutors feel as though they occupy the field in going after terrorists or terrorist financiers, and that they don't want the civil litigation to get involved in their criminal prosecutions. And so we find often that it's not a collaboration as much as it is an adversarial relationship with the government. Mm-hmm. I wish it wasn't that way, but that is the way it has been. And it's been that way for literally decades. I've been doing these cases for 20 years and it's been that way since day one. So I'll turn it back over to you, Jeff.
Okay. Thanks, John. That was something we talked about right before we went live. And my question was whether the spirit of ATA and JASTA could be improved on if we had some systematic cooperation between the attorneys representing large sets of victims, terrorism victims, and prosecutors handling particular cases. So that's what John was referring to. We have about 25 minutes. I want to get some questions from the audience. So if you have a question, please put it on the Q&A. You guys have answered one of my questions, which was, did JASTA significantly impact your litigation? And I find it interesting that with both Gary and John, JASTA, despite all of its the fear mongering about JASTA, has actually reduced the scope of ATA liability, and because of the tendency of some courts to require more post JASTA. Is that accurate? Is that about what the situation is?
I think that's probably accurate. Gary has had probably more of the decisions that really have you scratching your head, like the Weiss decision and the Freeman decisions really do make you scratch your head. I am, in full disclosure, I am co-counsel with Gary on those cases, but it's just it does leave you scratching your head that JASTA was intended to expand the scope of liability, and yet the courts have read it to somewhat narrow
it.
How you can bring these cases.
Yeah.
And who is a liable defendant?
Let me ask this question of all of you: and it's about the industry in general. Is the industry of terrorism victims finite enough that you know all the practitioners on the plaintiff side?
I would say, I won't say all, but certainly the vast majority. It's as a rule, both because JASTA cases have to be pled with such particularity, and because thankfully since 9/11, the number of sort of mass casualty events involving American citizens has been relatively contained. Obviously, there are service members who have been killed and targeted by various terrorist groups, but overall, really up until the October 7th massacres in Israel, the number of sort of terrorist attacks impacting Americans has been, sort of a random distribution. There were Americans killed in nightclubs in Paris, in Istanbul, and so forth. But you really, until very recently, there was a you might call a 15-year lull in sort of the targeting of Americans in terrorist attacks. So they do exist. There are, of course, cases ongoing, but one of the things Defense Bar likes to sort of characterize is that, JASTA and the ATA is an avalanche of litigation that's going to ruin the banking industry or wreck international finance, et cetera. And the reality, of course, is that there are, compared to, say, civil RICO or antitrust or other fields, the ATA is very circumscribed, and the universe of people who actually do it regularly and have cases, more than one case, is pretty narrow.
That brings up another question that I had, and that is, what would you tell somebody, say a young lawyer coming out of law school now, if they wanted to get into the victims counsel game? What would you suggest to them as far as career advice?
Find something else to do with your life that is less aggravating and less time consuming. I like to say that when I started, I had long flowing hair and it wasn't white. It's it's very gratifying to represent the victims and to pursue these claims, and you get a real powerful sense of doing something good in the world. But it, for every the reason we remember the biblical David and Goliath story is because it's the one time David won.
Yeah.
But that's not the way to bet. And so it is a very hard road. And that includes Dan's efforts as well. That case was brought in 2000. We're in 2024, and he's still fighting to hold accountable the organizations that he got a judgment against in 2004.
Yeah, although I will put in a plug for the U.S. Victims of State-Sponsored Terrorism Fund under the Special Master Ken Feinberg, because the goal of that, which was negotiated, I think, by your colleagues or your plaintiffs bar friends, was to find a way to reward victims with money that was seized through penalties and other things related to banks. And so when banks are hit by their regulators or by their prosecutors, either 100% or 50%, depending on the type of case, of those funds go into the U.S. Victims of State Sponsor of Terrorism Fund. And it basically provides for an annuity of all claimants. They get a certain amount per year from these fines. And I think there's some very happy people, because otherwise they'd be litigating this and searching for Iranian assets in their backyard, which is not easy to find. Let me just check.
That is true. But at the same time, the COVID lull hit that fund pretty bad. And so
is that right?
There have been limitations on the monies that are available in that fund literally since the second distribution. So it's, while it has made some people at least have something for their judgment, the amounts have become minuscule in comparison to the actual judgment.
The original. No, okay, that's interesting. Okay, let me just check the questions here. We had one question from one of our audience members that asked how they can help. And let me preface this question by saying, is there a role for ATA to play in the current conflict in Israel? Are there things that are not being done that could be done through the ATA?
Well, I would say that, first of all, in general, and I don't know what your experience has been, Jeff, from the government side, but terror financing and the growth of terrorist organizations trying to fight it through the courts, whether civilly or criminally, is like trying to hold back the tide. According to DOJ, I guess at the end of 2022, they announced the first criminal prosecution of a corporation under the material support statute.
Yep.
After 25 years, that was their first corporate prosecution. So the degree of accountability here that corporations in particular feel with respect to terror financing is very low.
Mm-hmm.
When they've been caught, for example, violating Iranian sanctions that help fund the U.S.C fund, it's really been a function of them, these giant corporations, being allowed to plead to much lower violations, pay a fine that they negotiate with the Treasury Department and DOJ, and go on their merry way. And as you see, for example, just to use one example, Standard Chartered Bank was caught in 2004, they paid a fine. They got caught in 2012, they paid another fine. While they were under government monitorship, they got caught for violating the terms of the monitorship, they paid another fine. So the deterrent factor here is extremely low. And it's very hard for the general public, I think, to appreciate the degree to which the folks on this panel and some of the other practitioners out there on the plaintiff side are really the only disincentive out there to intermediaries making money off of terror financing.
Mm-hmm.
It's actually a good business. And that leads to October 7th, because most of the operations financing Hamas and facilitating it have been untouched for a long time, and they also enjoy a degree of political diplomatic cover because, for example, Qatar and Turkey, which are two of the largest sponsors outside of Iran of Hamas, have, one's a NATO ally and one is has the status of a top non-NATO ally. So their activities are protected under that diplomatic umbrella,
right.
And they are almost, I won't say exclusively, but they are primarily responsible for the buildup of Hamas over the last 10 years.
Okay.
Jeff, if I could just add,
sure.
you know, as Gary noted, we're 24 years into the Boehm litigation, and I hesitate to comment because unlike Gary and John and you, who have devoted substantial portions of your life and your careers to combating terrorism, my involvement basically amounts to this one case. But the principle that's been at stake in the Boehm litigation over the last 7 years of litigation is whether a terrorist that's been found, a terrorist organization or an organization that's been supporting terror, that's been held responsible for it, can avoid liability as easily as just disbanding, dissolving, and then ignoring the judgment. And the reassuring, I mean, if anyone in the audience is looking for some reassurance over decisions over the last several years, Justice Scudder's opinion in our current Boehm litigation, which found that the alter ego theory does apply, and that invalidating essentially the ATA by allowing a judgment debtor to just dissolve and thereby avoid payment. Judge Scudder, understood our argument and adopted it, and believes that, and I think we've got a good Seventh Circuit precedent that the ATA still should have some teeth and should be enforceable. So it's not all despair. I think there's some promise out there.
Yeah. We got a question from an audience member, which is a good question. It's somewhat intriguing. It says, do some of the same NGOs that fund terrorist activity also front as humanitarian organizations whose reports are cited by the UN councils, such as HRC or Special Committee Investigating Israel's Treatment of Palestinians? Do you know if we have the same NGOs funding that activity?
Well, broadly speaking, the sort of two main sources of funding in the Palestinian terror arena, setting aside state sponsors, come from the network of Muslim Brotherhood organizations around the world. And then the other is the Popular Front for the Liberation of Palestine. And very little understood that the PFLP, which started as a Marxist organization, is particularly adept at infiltrating and presenting itself and its sister organizations as human rights organizations. So the short answer to the question is that through a network of PFLP related organizations, a lot of disinformation is provided and sort of filters into the humanitarian space because they're far more adept than the sort of hardcore Islamists at talking the language of human rights and so forth. Unfortunately, the U.S. government, even though they've designated the PFLP, has not taken action against its various tentacles that operate, including in the United States, under different brand names. So this is an ongoing problem. And I don't know, I'm not privy to deliberations inside Main Justice or elsewhere, but I don't think, I haven't detected a great appetite for sort of renewing efforts against operations that are being launched in the United States, either by the Muslim Brotherhood or PFLP, and certainly in Europe, with the exception of Germany. Most Western European states have allowed both Hamas-affiliated organizations and PFLP to thrive and really to, in some cases, really take over the human rights space.
Okay. Well, I got a question from an old colleague of mine, Mike Kraft from the State Department, and he wants to know, does anyone have figures on how many overall convictions or plea bargains have been brought under 18 U.S.C. 2339B, and how many involving Hamas specifically? The answer, Mike, is that I do have that information. I don't have it in front of me, but I'd be happy to provide it to you. we in the criminal prosecution area got fairly deep into the Hamas and Muslim Brotherhood litigation, with not only the Holy Land Foundation case, which was the subject of a program on extremism event, a Zoom event a couple of weeks ago, but that was really from 9/11 until I'd say 2009. And one of the nice things about what you guys do is that it doesn't involve a lot of political will. It involves the political will of your law firm, basically, whereas prosecuting, we did prosecute a lot of Hamas characters shortly after 9/11, as the Holy Land case shows, and we got some individuals as well. But I'd be happy to provide that information offline to you, Mike. Thank you. Let me just check.
I would only add, if I may, that
Sure.
the HLF and a little bit relating to Kind Hearts, which kind of took over some of its operations. HLF was really the last time DOJ really put a tremendous amount of effort. It was in a 2004 indictment and ultimately a 2008 conviction. So we're talking about, more than a decade,
Yeah.
15 years, in which there are material support prosecutions. You see them for ISIS members, for Hamas, but they tend to be low-level operatives, sometimes sort of spontaneous, supporters who want to fly to Syria to join ISIS, or they're involved in relatively low-level operations. With Hezbollah, there's been a little bit more. There's been a couple of prosecutions where FBI or DEA undercovers have been involved in, weapons purchases or things like that, where a couple of Hezbollah operatives have been arrested and ultimately prosecuted. But even to take an example that's current today, very recently, in the last 6 months or so, the U.S. government finally apprehended Mohammed Bazi, one of the most important Hezbollah facilitators, and really a key node in Hezbollah and the Islamic Revolutionary Guard Corps, funding operations globally. He's a specially designated global terrorist as well. But when they actually unsealed the indictment against him, they charged him with violations of sanctions against him. That is, no material support violations, nothing that would send him away for 20 or 30 years, but charges that scream plea bargain. And we saw that the other comparable person that was apprehended in Morocco, Qasim Tajuddin, wound up serving like 3 years and being released on compassionate grounds to Lebanon. Again, another one of the most senior Hezbollah operatives out there. Accountability is in short supply, but to Dan's example, 24 years in, those of us who just refuse to quit at it and insist upon continuing the fight, that's really what it's all about. It's very little glamour, but it certainly requires a dogged determination.
Okay. Well, we're running out of time. We have about 6 minutes left. I'm curious about how the victims find you guys. Is there do you do much marketing, or is it just word of mouth, or how do you find that the victims come to you and you have to consider whether to take their case?
With Motley Rice, we have co-counsel throughout the country who they'll have somebody come to them and kind of pose their case, and then they call us and say, we can't handle this, but I know you do this. Or people just kind of look. There aren't a lot of people who do this, so they look and see who's doing these types of cases, and we get we'll get a random inquiry out of the blue, and that blossoms into something bigger. So
yeah, Gary, is that true of you as well?
Yes, I would say that primarily we're contacted by other law firms
Yeah,
who know that they don't want to embark on a 10-year scorched earth litigation, but have a client.
yeah,
And I would say the other aspect of it is that we do get contacted by a fair number of individuals who've just had some terrible experience in the world. They were abducted in Somalia, or their daughter was an aid worker in Afghanistan, or what have you. And we don't always have a case. I mean, sometimes there's terrible events, but there's no obvious case or defendant. So where we think we can help, we do, but it is very challenging because, not every terrorist attack or every tragedy has a legal solution.
right. No, I think we all understand that. Well, my last question is for all of you, and then we'll sign off. But the question I have for your input is, what do you see as trends in victims litigation coming up in the next 10-year cycle? Is that a tough question?
I would say it's a tough question because the law is constantly evolving. And there's currently a case up before the Supreme Court from the DC Circuit involving JASTA. We don't know whether the court will ultimately take cert, but they've asked the Solicitor General's office to weigh in.
Mm-hmm.
There's another John's 9/11 case. I think they're still briefing the last part of it, but that's going to Judge Daniels by the end of this year.
Yep.
And there's another case in the Second Circuit called Wildman, which was just last week. So, the state of play, we didn't really get a chance to talk about it, but the state of play after the Supreme Court's decision in Twitter v. Tomnet is up for grabs. So the future is up for grabs.
Yeah, that's something, unfortunately, we ran out of time and we weren't able to discuss social media company liability in light of Tamnia, because that's something, maybe we'll do another event on that, because that's going to be a hot area, I think. I sense that the immunity provision of 230 of the Communications Decency Act is going to be scrubbed, or is going to be changed in some way, because I think what we hear about social media companies is that they have not taken proper attention to really true externalities by their customers, especially young people. And so I think that's what's in the offing for that. But anything else from you guys, John, Dan?
No, just thanks, Jeff, for giving us the forum. I think I learned a lot today, and it's been a pleasure.
Yeah, thanks, Lorenzo Vedino, who is the executive director of the program on extremism here at GW. And I'm a professor at GW as well, and I spend time in my class, which is on prosecuting terrorists. I spend time trying to encourage more interplay between the program on extremism and the law school, which is that's sort of why we have the event that we had today. So, any last minute questions or comments?
I just appreciate the opportunity to talk today, and thank you for inviting us.
Well, thank you. I appreciate your time, and Dan and Gary, appreciate it. Take a look when you get off this call. Take a look at that report that I referenced earlier. I think it'll fill in a lot of details. What I find kind of fun is putting a taxonomy on the defendants who are sued under ATA. You have banks, you have multinational companies, you have charities, as in the case of Boeing, and then you have this. I included the frivolous cases in the report as well. So you have a guy who was upset because his cable went out when the game was on, that was terrorism in his mind. So he sued the cable company for that in Hawaii. That had been a storm or something. So I included those cases because I kind of find them fun. But anyway, I hope we would appreciate your comments on this. I know Lorenzo would. And with that, I think we're out of time. Thanks, Gary Osen, Dan Schlesinger, John Eubanks, and Rosa. Anything else, Rosa, from your perspective?
Yeah, no, that's it. Thank you very much, everyone. And yeah, it was a pleasure having you all here. And thank you also for the audience for being here and simulating such a good conversation. So it was great. Thank you.
Okay, great. Thank you.
Thank you.
Thanks.